Welcome back, future lawyers. This is Pinay Jurist on YouTube. I hope everyone is doing well. In this video, we are going to review the principles in Article 6 of the 1987 Constitution, the Legislative Department. Let's start. As an overview, these are the topics covered in this video: legislative power, delegation of legislative power, exceptions, constitutional principle of bicameralism, qualification of members of Congress, privileges, disqualifications, the party list system, enrolled bill theory, one title, one subject rule, and the electoral tribunals. Legislative power is the power to propose, enact, amend, and repeal laws. It is vested in the Congress, except to that extent, reserved to the people by the provision on initiative and referendum. Initiative is the power of the people to propose amendments to the Constitution or to propose and enact legislation through an election called for the purpose. It may be an initiative on the Constitution, initiative on statutes, or initiative on local legislation. Referendum, on the other hand, is the power of the electorate to approve or reject legislation through an election. Delegation of legislative power. As held in Rodrigo versus Sandigan Bayan, the rule is that what has been delegated cannot be delegated, or as expressed in a Latin maxim, potestas delegata, non delegare potest. This doctrine is based on the ethical principle that such a delegated power constitutes not only a right, but a duty to be performed by the delegate. Congress, however, may delegate to another branch of the government the power to fill in the details in the execution, enforcement, or administration of the law. Are there exceptions to this rule? Yes. The only recognized exceptions to the non-delegation of legislative powers would be a delegated legislative power to local governments which, by immemorial practice, are allowed to legislate on purely local matters, and b. constitutionally grafted exceptions such as the authority of the president to, by law, exercise powers necessary and proper to carry out a declared national policy in times of war or other national emergency, or fixed within specified limits and subject to such limitations and restrictions as Congress may impose, tariff rates, import and export quotas, tonnage and wharfage dues, and other duties are imposed within the framework of the National Development Program of the government, as ruled in Bellica versus Ochoa. There are two tests to determine the validity of delegation of legislative power: the completeness test and the sufficient standard test. A law is complete when it sets forth therein the policy to be executed, carried out, or implemented by the delegate. It lays down a sufficient standard when it provides adequate guidelines or limitations in the law to map out the boundaries of the delegate's authority and prevent the delegation from running riot. To be sufficient, the standard must specify the limits of the delegate's authority, announce the legislative policy, and identify the conditions under which it is to be implemented. Abacadaguro versus Purisima. Moving on, the constitutional principle of bicameralism. Section 1, Article 6 of the 1987 Constitution provides, the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives. Congress consists of two chambers, the Senate and the House of Representatives. A valid exercise of legislative power requires the act of both chambers. Corollarily, it can be exercised neither solely by one of the two chambers nor by a committee of either or both chambers. The following are the qualifications of members of Congress. Senator, a natural-born citizen of the Philippines, on the day of the election is at least 35 years of age, able to read and write, a registered voter, a resident of the Philippines for not less than 2 years immediately preceding the day of the election. Qualifications of a member of the House of Representatives. A natural-born citizen of the Philippines, at least 25 years of age, able to read and write, a registered voter in the district in which he shall be elected, a resident thereof for a period of not less than 1 year immediately preceding the day of the election. The party list system. Who may participate in the party list system? 1. National parties or organizations. 2. Regional parties or organizations. And 3. Sectoral parties or organizations, which may either be marginalized or underrepresented or lacking a well-defined political constituencies, and advocacy pertains to the special interest and concern of their sector. Principles of the party list system. 1. The 20% allocation. The combined number of all party list congressmen shall not exceed 20% of the total membership of the House of Representatives. The 2% threshold. Only those parties garnering a minimum of 2% of the total valid votes cast for the party list system are qualified to have a seat in the House. The 3-seat limit. Each qualified party, regardless of the number of votes it actually obtained, is entitled to a maximum of 3 seats, 1 qualifying and 2 additional. Proportional representation. The additional seats which a qualified party is entitled to shall be computed in proportion to their total number of votes. The Supreme Court has recognized the power of the COMELEC to cancel a political party's registration. The power of the COMELEC not only to register political parties but also to cancel their registration emanates from no less than the Constitution. Privileges of the members of Congress. 1. Freedom from arrest. A senator or member of the House of Representatives shall, in all offense punishable by not more than 6 years' imprisonment, be privileged from arrest while Congress is in session. Privileged speech and debate. No member shall be questioned nor be held liable in any other place for any speech or debate in Congress or any committee thereof. Disqualifications. Incompatible office. No senator or member of the House of Representatives may hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including GOCCs or their subsidiaries, during his term without forfeiting his seat. Forfeiture of the seat in Congress shall be automatic upon the member's assumption of such other office deemed incompatible with his seat in Congress, except if the position is held in an ex officio capacity. Forbidden office. Neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. No senator or member of the House of Representatives may personally appear as counsel. Upon assumption of office, he must make a full disclosure of financial and business interest. He shall notify the House concerned of a potential conflict of interest that may arise from the filing of a proposed legislation of which they are authors. The enrolled bill theory. An enrolled bill is one duly introduced and finally passed by both houses, authenticated by the proper officer of each, and approved by the President. The enrolled bill is conclusive upon the courts. The court is bound under the doctrine of separation of powers by the contents of a duly authenticated measure of the legislature. Enrolled bill prevails over journal entry except as to the matters which, under the Constitution, must be entered in the journal. One title, one subject rule. The requirement that every bill must have one subject expressed in the title is satisfied if the title is comprehensive enough to include subjects related to the general purpose which the statute seeks to achieve. One title, one subject rule is the principle that the title of the law must not be so uncertain that the average person reading it would not be informed of the purpose of enactment or put on inquiry as to its contents, or which is misleading. Next, matters which, under the Constitution, are to be entered in the journal. 1. The yeas and nays on the third and final reading of a bill. 2. Veto message of the President. 3. Yeas and nays on any question at the request of 1/5 of the members present. And 4. Yeas and nays on the repassing of a bill vetoed by the President. The electoral tribunals. The electoral tribunals of the Houses of Congress shall be the sole judge of all the contests relating to the election, returns, and qualifications of the respective members. The House of Representatives Electoral Tribunal, or HRET, may assume jurisdiction only after the winning candidate, subject of the election controversy, shall have been duly proclaimed, has taken his oath of office, and has assumed the functions of the office, because it is only then that he is said to be a member of the House. Only then that the COMELEC's jurisdiction over the election contest relating to his election, returns, and qualification ends. The Electoral Tribunal is independent of the House of Congress, and its decisions may be reviewed by the Supreme Court only upon showing of grave abuse of discretion in a petition for certiorari under Rule 65 of the Rules of Court. We end our review here for now. And have a nice day, and I wish you all the best, future lawyers. Thank you.